Mr. Raimondi, Your Excellencies, ladies and gentlemen. Last year, we celebrated the 65th anniversary of the European Convention on Human Rights. 65 has been the retirement age in the Netherlands for many years. And reaching that age is still regarded as something special, as a cause for festivities. And it is an age that makes us want to look back and see what has been achieved. So it won't surprise you that many celebratory events took place. But if they showed anything, it was that the convention is very far from being able to stop working, lay back, and relax. Quite the contrary. It seems that ever more human rights problems arise all over Europe. There is the situation in Turkey, where judges have been dismissed and journalists and individuals are being prosecuted for allegedly having supported Gulen. We have Hungary and Poland, where the work of constitutional courts is curtailed, and there is serious pressure on minority rights and religious freedom. We know that in France, an emergency situation was announced nearly a year ago, which has resulted in serious restrictions of individual liberties and fair trial rights. And there is the United Kingdom, where the Brexit seems a mere forewarning for its wanting to leave the European Convention. And I am afraid that I can continue for quite a long time, summing up urgent threats and risks to the protection of human rights in nearly all the European states. So now, 66 years after the birth of the European Convention, there are still many reasons to worry about the protection of our most special rights. Clearly, we continue to be in need of a European mechanism that can be of help in this respect. And we can consider ourselves lucky that so many years ago, the drafters of the Convention did not only lay down a very well-considered list of human rights, but they also conceived a system to monitor compliance, an alarm bell that could be rung by states as well as individuals. At the time, it was hoped that the mechanism would scarcely be needed. And I think that none of the drafters could ever have expected that today, the court would be one of the world's most influential and effective international institutions. Surely, it is a bad sign that 40,000 to 60,000 complaints are brought to this court each year. But at the same time, that very fact illustrates the public support for the court and the trust individuals put in the ability of the court to provide for protection and offer redress. It is also well documented that the court's judgments have great impact on national law. In the Netherlands, for example, the entire system for legal protection against administrative decisions was overhauled after just one judgment of the court told us that the old system offered too little access to court. The Nordic countries have abolished their age-old closed shop systems, which compelled workers to become members of trade unions. In Italy, many efforts are made to make court procedures more effective. And Central and Eastern European states actively try to comply with the court's judgments when restoring property that has been nationalized under communist regimes has to be given back to the owners. In fact, the list of such changes also is endless. At some point, every single state has made at least some structural changes in national law and policy in response to a judgment of the European Court. Of course, states may grumble and protest, or they may criticize the court for making inroads on their national sovereignty. But it turns out that really many of the court's judgments are complied with. As a result of the court's work, national legislation is adapted, domestic practice is changed, and in short, national law is transformed. This very special transformative power can be explained in many different ways. Explanations range from the independent status of the court and the authority of its judges, to the socializing effects of the public nature of the court's judgments. But such explanations are for social and political scientists to give. As a legal scholar, for me, the best way to explain the court's transformative power is by highlighting one of its most important tasks: its role of interpreting the convention, explaining its wording, and determining how the various provisions should be applied in concrete cases. At this point, I need to emphasize that the court has no strong legal tools available to guarantee the execution of its judgments. It cannot impose a fine if a state does not comply. And there is no European police force that can bring a state to justice. And for the court, this means that it can help transform national law only if it manages to convince the national authorities of the rightness of its decisions. So the question that I would like to discuss is, what is contained in the court's judgments that makes them so persuasive, and that makes that states comply even without a mechanism of coercion? I think that at least part of the answer can be found in the way the court has fulfilled its role of interpretation. When the first applications to the court started to trickle in the 1970s, they gave it occasion to start developing the convention. And indeed, the court's judges made good use of this unique opportunity. And they provided a set of very well-considered general criteria, principles, and notions of human rights adjudication. In fact, all judgments of this very first period can rightly be claimed to be classics. And they are still read and studied by law students and professionals alike. To lawyers, I need but mention the doctrine of the margin of appreciation, common ground review, the fair balance test, methods of metateleological and autonomous interpretation, and all of these were developed at the time. But still, of course, the creation of such standards and doctrines may be an important step, but it is not enough to guarantee their implementation in national law. There is an additional factor that is needed to explain the successful transition of the court's standards and to explain its transformative power. And this factor is the gradual but very deep embedding of the court standards in national case law. Importantly, if you look back at the early days of the convention, you can see that human rights law was not yet very strongly developed on the national level. Of course, there are some exceptions, such as Germany with its very active federal constitutional court. But in some states, it was difficult and very uncommon for individuals to complain about violations of their human rights before their national courts. In the Netherlands, again, for example, individuals could not complain before the courts about legislation that infringes their constitutional rights, such as the right to freedom of religion or property rights. And also, in the Nordic states, it has long been considered very difficult to accept that a court would set aside legislation for its incompatibility with fundamental rights. In the United Kingdom, the convention also could not directly be invoked before the courts until 1998. And of course, in the Central and Eastern European states, the convention did not even have force of law at that time. But things started to change over the 1970s and 1980s. It is well documented that the human rights discourse gained enormous importance in these years. Citizens in Western Europe became much more active in bringing cases to the courts in order to influence legislation and policy making. And they really discovered the European Convention as a good source for doing so. And it was also that other European court, the Court of Justice of the European Union. Especially in the 1970s, that court took a few very bold steps, and it made it possible for national courts to review and even set aside national legislation and decisions. You can understand that such developments brought about a steady increase in human rights adjudication in many of the European states. Of course, to decide all these new cases on human rights, national courts needed standards, they needed criteria. The point is that human rights are often formulated rather openly, and much is needed to discover what exactly is covered by, for instance, the right to respect for one's private life, or to explain why an infringement of the freedom of expression can be justified sometimes. In many of the European states, that kind of standards were lacking because the national courts were so unused to dealing with human rights cases. So again, it's easy to understand that lawyers and interest groups very quickly discovered that the European Court did provide for such standards, and that they were very useful and very well considered. So parties to court proceedings eagerly invoked the court's case law. And in response, many domestic courts adopted the court standards and tried to fit them into their own argumentation and in their own normative traditions. So you can see, for instance, in Austria and in Belgium and the Netherlands, that courts by now really have taken to applying the Convention standards in almost all cases on fundamental rights. And even in states with well-established constitutional doctrines, courts have found reasons to apply the European standards. So, in various ways and in various degrees, it appears that most courts in the older Convention states have learned to apply and to value the European Court standards and doctrines. And by doing so, they have set an important example to the states which acceded to the Convention in the 1990s. And post-communist Europe also has derived their own benefits from the Convention standards. In many of the Central and Eastern European states, the Convention really has proven to be of great importance to the development of the new democratic systems. And one of the explanations for this is that the possibility of applying the court standards has provided the national constitutional courts in these states with the necessary power to effectively exercise their supervisory role over the national legislative and executive bodies, and to correct them if needed. So, in fact, an important explanation for the court's success can be found in its ability to set high-quality standards at a time that national courts were in particular need of them. In turn, the national adoption of the court standards has brought about an even deeper impact of the Convention. What has happened is that in applying their new doctrines and criteria, national courts started to reinterpret national legislation and to invalidate decisions which they found to be inconsistent with the Convention. And in response to such national judgments, this has led to many changes in legislation and in administrative decisions, and importantly, also in a learning effect for national legislators and administrative bodies. In many states, it is really actively tried to anticipate and prevent convention violations by making legislation convention-proof in the first place. Now, of course, I will be the first to admit that this is a slow and halting process. Surely, many of the human rights problems of today cannot be solved by means of judgments of the European Court, however good they are and however useful standards they may contain. And I also agree that empowerment of national courts can solve human rights problems, and especially systematic problems, only to a certain degree. But still, the process I've just described is the only one that, to my mind, can explain how and why an international institution such as the court really has been able to exert such great influence on national law. And I am convinced that the court has made, by doing so, an impressive contribution to the national protection of human rights. And that is why I think that the court deserves this medal, perhaps more than any other institution or person in Europe. And I hope it will encourage it to continue its great work, even long after the Convention's retirement age. I thank you for your attention.